Welcome back. We had some technical difficulties. We told you guys and joked about it. You've heard it on several panels. We are becoming our parents, and screw this chip out. Just be. But we won't be that way with AI. We gonna make sure that we learn AI. We got an exciting panel for you. Thank you for those of you who stayed long enough for the award ceremony and the lunch. We had quite a few awardees. Once again, we want to, before we get started on this next dynamic panel, we want to thank our sponsors. That is Perkins Coie, Wilmer Hale, Greenberg Trarick. Let me make sure I don't leave anybody else out. Ice Miller, Verizon, and Block. Without their contributions, this would not be possible. So we're very grateful. Without further ado, because we started late due to ours before technology. I'm going to get out the way. Ed, are you moderating? All right. Well, you won't do what you do from there. I think I could cut my mic off. You good?
Yep.
All right. Let's give them a hand.
Vira? No, you got person.
Great. Hey, thank you and welcome everyone. My name is Derrick Maultsby Jr. I'm a senior associate attorney at Frost Brown Todd, where I am in our private equity and venture capital practice group, as well as our technology transactions and data privacy practice group. I'm really happy to be joined by two esteemed panelists to talk about innovative areas in sports and entertainment today. And without further ado, I'll let them introduce themselves.
Please go ahead.
My name is Jessica Wright. I am general counsel at DC United, DC Power FC, Audi Field, and various affiliated entities and stadiums and teams. I am multi-practice attorney with regards to the organization. I handle our M&A, our corporate governance, our player contracts, litigation, you name it. If it comes through the stadium, it's coming through me. It doesn't usually get signed unless I've seen it. If it does, there's usually a problem. And the landlord-tenant side of things, as we also have various teams that play in our stadiums and use our training facilities for their own athletic endeavors.
And now, how's everyone doing? My name is Edward Fultz. I'm an entertainment media associate at Reed Smith. I'm a fifth year. Originally, I'm from Atlanta, Georgia. I went to Morehouse College for undergrad, Howard Ball for law school. So I'm an alumni of this great institution. I appreciate it. All you really did back. My job is I monetize talent, ideas, brands, and businesses in relation to sports, music, movies, video games, influencers. So I love entertainment as a whole. Sports, of course, is part of the practice. So I deal a lot with the promotions, sweepstakes, offers, disclaimers, contract negotiations, licensing, merchandising, and of course, AI, influencer world, the engagement of who has what, when, and where. So that's what I've done the last 5 years, and I appreciate it, Victor.
No, absolutely. And so last evening, I had the opportunity to go to a Wizards game. And as I was sitting there, I was starting to think about how so much within a stadium really relies on connectivity within the Internet of Things. And so I was curious, Jessica, what is some of the liability and some of the thought process that goes behind stadium operators when Wi-Fi and other connectivity issues can interfere with that fan experience?
Yeah, so much of the fan experience is based on Wi-Fi connectivity, whether it's using our app to pay for food, to order items, to find their seats, their tickets, to get into the stadium. If you've purchased any ticket, you are going to get that. Make sure you download this ticket to your Apple Wallet before you come to the stadium from every stadium. Our two venues, one is a 5,000 seat stadium. We're not going to have the same issues. We don't have enough. There's not going to be enough people going that are going to impact the Wi-Fi there. Audi Field is a 20,000 seat venue in the middle of downtown DC, or in Navy Yard, I should say. And so there's a lot more people surrounding it that could impact Wi-Fi. And if we have our ticket kiosks go down, we can't get people in. So there's a lot of, and then people are going to be angry and then they're going to want refunds. There's a lot of that. But within the stadium, there's various technology used. The Just Walk Out technology, for example, as you may have seen through Amazon. If you can't use that, if you can't scan, if the systems go down, so there's a lot of planning involved in segregating networks so that we don't have too many people on one, right? Keeping the media on one, keeping fans on a different one, keeping our internal people on a different one. And then being soccer, we actually use the video assistants, referees. So having a dedicated line for that, since they sit down in Atlanta, and making sure we don't lose the feeds or connectivity there is all something that has to be taken into consideration and upgraded with technology. Every couple of years, we're changing everything out and switching it over.
Absolutely. And just
No, I was going to say, how's the Wi-Fi when Messi comes to town? That was the big one.
We're still only a 20,000 seat arena, so it's helpful. But it's insane. The extra precautions and security details and everybody else that are going to be there and need additional bandwidth are things that have to come into consideration. If we have to bring in extra relays or whatnot, it's all stuff we consider.
absolutely. And keeping with that train of thought, what are some of the data security and privacy risks there? Obviously, what a target for bad actors in a stadium, in an arena, and obviously folks are trying to text and be connected to things. There's the opportunity to connect to maybe a falsely advertised Wi-Fi, and find yourself victim there. Is there active ways that you all are monitoring those risks and trying to minimize them?
Yeah, I mean, we all try to work with the most reputable of companies, use, major providers, put in place various technology monitoring systems, vSOCs, things like that to protect all of our different avenues. We happen to have a sports book within the facility, which adds an entire another level to things, but also made us get more secure. But being a, 7-year-old venue at this point, 2018, we aren't as technologically behind as some of the other stadiums and arenas maybe, just because we're so new.
Yeah, absolutely. Thank you, then. Looking to the future a little bit here, another thought I have is how facial recognition is starting to become a tool, not on the fan experience side, but also on the security and safety side. Could you speak a little bit to your thoughts around facial recognition? Maybe not exactly what y'all are implementing, but just your general thoughts.
Yeah, I mean, at this time, we aren't using facial recognition. Some stadiums are, some facilities are. I think for me personally, I'm watching what's going on out there and what the concerns and the lawsuits. And I believe there was a law firm whose entire staff were excluded from entering an arena in the New York area recently. And so seeing how that plays out to figure out what the best practices are moving forward and how it's going to help us to provide that security. Obviously, there's a lot of cameras and footage and things like that can be scanned through facial recognition in any sports arena and sports venue, depending on what happened. And I know some of that stuff happens when things go wrong. But so far, fortunately, I have not had to directly deal with any of the things gone wrong that required me to use facial recognition.
No, that's great. That's great. And kind of keeping, in line with this stadium and fan experience thought process, I wanted to go into sort of the ticketing and the fan experience side of that, keeping with sports. Digital ticketing systems, I imagine there's just a bunch of issues, especially as folks have tried to introduce NFTs and sort of blockchain technology to the ticketing world. How do you view ticketing? And Edward, please, add in as you can when it comes to the reselling and the verifying of tickets in secondary markets and so on and so forth.
Yeah, definitely the secondary markets, right? Not just any companies on there. We all know those tickets we're going to get for any live sell events, sporting arenas, concerts, boxing matches, and also small lodging. So recently, the FTC last December, I believe, issued a final rule on the junk fee removal. So what that means is it applies to all businesses, individual related, involved with live events and small lodging, inclusive motels, hotels, any type of small lodging is not defined in the rule, but usually spots you stay there for temporary periods of time. And it bans all junk fees. What are junk fees? They are convenience fees, transactional fees, service fees that we don't know nothing about, but we all pay, right? So now the total price, which still kind of being disputed against, the total price must be clear, bold, and conspicuous right before you purchase the ticket or purchase the attendance fee to attend the event. And so with that update, that just came out in December. So we'll see the next 45 months how that applies, right? So as I know, it does not apply to airlines, does not apply to other things, but it does apply to the sporting events where people know exactly if you use one of these third-party secondary markets, hey, what's the price going to be before I get to put in my personal information. So going back to digital ticketing, I mean, the premise of it all is trying to make this easier for the band, like the paper concept, the QR code, the scanning. Like even when you go to, down the street, the Wizards game, right? It's a QR code that scans, right? You can screenshot it. You can take a picture, send to your friend. It's supposed to make it easier, more secure, XYZ, right? But the problem is, one, if your phone's not working or your phone has the battery, then what happens there, right? People that, well, I paid for something, I need to get into the event. So those are things people are working on, but I do believe it's for the better, right? It does make it, if it isn't working right, it does make a better fan engagement, fan experience, so I can just walk in and enjoy the show, enjoy the event. I don't know, Jessica, do you have any other insight about that from your end?
Yeah, it also makes it more secure and easier for us to track who is buying to resell and who's violating the terms of our ticketing, right? Our terms are posted on websites, they're on Ticketmaster, they're on everywhere that we sell our tickets, and we don't allow for third-party resellers. You can as your individual sell them, but if we notice, because everything's digital, that you have purchased all these blocks of tickets just to resell, especially for the Miami game or things like that, it is always going to be something we can track. And the digital nature of this makes it easier to track. It also makes it easier if I purchase a block of tickets, I then can send them out to everybody I need them send them to without having to make everybody go buy them in the same section. So it makes for a better fan experience in a lot of ways and allows us to make sure that anybody buying the tickets is accepting the terms and the release of liabilities and everything else that goes into the digital ticketing purchase.
Absolutely. And to that point, I mean, I know bots and automated systems become such a big issue. I think, Ticketmaster and some of the other larger resellers have had to try to battle that. Have you all had any insight into how to stop bots from doing that bulk sales and ticketing?
Yeah, I have 2 different ticket retailers, and that's both on them.
Yeah.
Put that liability on them on the contract. That's all.
That's true. Right? It should be on them, right? Because they're the one that controlling the system. They're controlling the analytics. They're the one controlling the functionality of the site. And so these bots that do come by group prices of wherever event may be, it should be on them because they're the one that can control and stop it, right?
Yeah. Yeah. You see folks on the internet who say, well, we should just go back to the old days of a box office, right? And I was like, yeah, the nightmare that a box office would be, but there is a traditional aspect that I think technology is trying to solve, which is you do lose something with the current ticketing system where, to your point, it's more secure. It's it's a QR code. It's on my phone, but you lose the nostalgia and the memorabilia piece of it that ticketing used to bring. And I know that some companies are trying to solve that, right, through other ticketing options. NFTs was sort of sought to be maybe, and still could be, one of those options. Did either of you have any insight into what maybe tech companies that are out there can do to come alongside the ticketing process to create that memorabilia aspect?
Well, some are already doing it, right? Like you said, on your phone, whether you have an iPhone or Android, the way you collect the ticket could be kind of personal, right? So when you go to a certain game, it could be like a customized ticket on your phone. You can have that as a wallpaper. You can have that in your digital wallet. So they all kind of do it in a way to make sure you personalize it. This is your ticket because it has your favorite player on it. It has their favorite, seat on it, wherever it may be. Especially if you're like a season ticket holder, I think definitely get more personalized than that, right? Because now they want to engage with you, invite you to events. So I do think either the service provider or the ticket system are trying to do it, right? But at the end of the day, the ticket itself, those days, unless you're going to a Broadway, maybe something like where that traditional meet is still there and people expect that. But I don't think we can go back to the bounce office. That digital thing told me a thing.
We actually do maintain a box office, but it's primarily to help people with their digital tickets. I just went to the Super Bowl and I was like, I wish I had the ticket stub. There was no ticket stub, right? But I think it's something that we also try to keep in mind. Soccer is a world sport, right? So there are still many places where the digital doesn't work. The clientele that may come into the stadium for certain of our games that we host, friendlies in particular, international friendlies, they expect to have tickets and they buy and only use cash. So digital does not work. And purchasing through Ticketmaster that same way doesn't work. So that we do actually, in very limited circumstances, have consignment physical tickets that we print. And they are very much usually for international matches. And at that point, you can buy them at the box office, but we're only printing so many of them because most people do have some type of smartphone or access to ticketing.
No, I like that. Yeah, I'm a season ticket holder for a few different teams, and some of those teams actually will send me a nice block of tickets before the season, right? And that's like a benefit to being a season ticket holder, and I get to frame that every year because I also come to the digital ticket, but I don't need to break them and use them. So there is something there, right? And I do think we'll see a lot of innovation, in that area, and I'm sure we'll get to sit down together at some point in the future and kind of talk about some of the legal aspects of that. But in the meantime, I want to go a little bit more to the athlete side and talk about what innovations are being adopted to optimize athlete performance. And I think we had a really good in our sort of pre-panel prep talk, good conversation around some of the technology that's being introduced. If you want to share it with the rest of the folks.
No, go gorgeous.
I'd say for soccer in particular, our athletes all wear biometric trackers that track their heart rates, their blood pressure, their how many miles, steps they're moving, trying to keep a consistency with them and also watch for any things that could go wrong. And obviously there's a lot of concerns that come with that. Tracking someone's body temperature, heart rate could all lead to invasions of privacy. Obviously we get signed off contracts and things like that for these individuals. So it's a little different, but even from the Oura Ring, the Apple Watches, all of these things track something, and using systems to compile that data to enhance performance is what are being used. And I know we're likely going to move into this area. AI is being used in a lot of these to further track that and give predictive information. And that's where things get a little bit more hairy.
Yeah, and then sure, the introduction of the women's team, they make it easier with collecting their data, analytics, and predicting how people, injuries, the sustainability, and all that. And also, I'm not sure what she said, data, the collection of data, right? This is sensitive personal information and biometric information is the big tick out, right? We want to know when, you're conditioning, when you're training, when you're not. And that could be used as a means of, as we learn from recent trades in the NBA, are you conditioned enough? Yeah. Are you, do you really love the game? Because we see here they're not working out as you say you are. So like you mentioned, it's like an invasion of privacy because, sign your contract, and I guess I'm an employer of you, but that don't mean that you have access to all my information all times, right? So it does pertain, it's a nuance of it all. Like it depends, right? It depends like, what information is allowed, what's not, and what you have access to in those certain time periods, right? Especially in the off season, during All-Star Weekend, during all these breaks. Why wouldn't collect it there, right? To market and promote to their fan base, right? Whatever they may be. How do you know certain people are watching you, whether age group, whether the demographic, and whether the geographical location.
And on that, the protection of that data, right? If you have this tracker and you're required to wear it at all times in whatever sport I don't know if this happens in soccer, but if you are wearing this Apple Watch and I know your location at all times, well, if somebody hacks in and gets into that data and knows where you are, we've just now risked your security, not just your data, and the hackers are after that all the time. No, who's injured, who's not, who are they not telling us is moving slower than normal, whatever, for betting purposes, now that's a huge thing in the United States. But your physical security is now at risk if somebody can hack in and see your actual physical location in real time.
Yeah, I was going to say, it's just all of it comes down to sports betting, money in college, right? Especially nowadays where a good amount of people just watch sports because of that. And now they want to see, okay, is he going to be injured or is she going to be injured in the next game or so? Okay, let me do the over and under and all those. So that's probably the biggest ramification of all this when it comes to the sports betting wrong.
Yeah, data security be so important. And I think another really interesting aspect, in Jessica, you mentioned it, the predictive analytics aspect. And I think in women's sports, especially, it could play, a potential huge controversy around, we're around contract talks. I have certain predictive analytics or I have certain biometric information about you that maybe tells me, are you about to experience a certain, health
are you
condition?
Yes.
And, I do think teams are going to have to manage that. I think the leagues are going to have to manage that and hold teams accountable because as we all know in sports, it's about finding an edge, right? And it's very cruel what some folks might do to get that edge.
And law does not allow for the discrimination of women that are pregnant or firing of them or terminating their contracts, and all of that stuff is taken into consideration. Yeah. And biometrics, as any female that has an iPhone knows, it wants to track your cycle. It wants to know your temperature at all times. And if you put that in there, or any of the data that we're tracking is even more specific and scientifically accurate, it is something that could easily be used like, oh, her numbers show that she might be 3 months along or 2 weeks along, whatever you're going to be able to figure out as time goes on, because it's going to get easier and easier to figure it out. Okay, don't sign her next year to this contract. And that is going to become a problem that I think is going to start showing up. I mean, I know we're already seeing some of this in the WNBA. My team has only been around since July, so I haven't had to deal with this yet, but for the women's team. But it is going to be something that we have to watch. And I think there's going to be even more ramifications. Soccer is young. We are allowed to sign players at 14 years old on the men's and women's side. Think about that. Is this player sexually active? What data are we tracking at 3 o'clock in the morning? We know where their location is if we're requiring them to keep that on. I employ these individuals. I can't track my other employees that way. Why can I track them? So figuring out the law hasn't caught up with the science and the technology that we have in front of us. So it's a matter of staying at the forefront of that and figuring out how we don't get in trouble or have our sporting side want to do things that are going to give them that edge and give them that next big break, but are also violating the rights of all of the employees and the athletes.
Absolutely.
No.
Yeah, I do think some of that, the litigation that will occur from that, right? Because the team's going to come with, well, your numbers are this and the comparisons, and we're cutting you based on your performance, right? Like, very rarely will a team feel like they probably have the ability to cut a superstar or even want to cut a superstar because of how they're tracking their health and what maybe that implicates. But I think there will be a huge numbers and stats and all these things versus, well, you were tracking this and it's so convenient that around the time that I was, I had this, I get cut or I get traded or, whatever it may be. So I do unfortunately think we will see that play out. And so I guess the other piece of that, we talked about the privacy and the things like that. How do we internally maintain privacy compliance with such important information, biometric data, PHI, all that stuff that we have? I imagine there's a pretty complex privacy program internally.
That yeah, these are the silence, right? Test is a strong word. I think the way to mitigate that is you got to update your privacy policies, right? Your data privacy, then there's your APIs, your website, your custom cache, and that law is ever evolving, right? To this day, there's still states updating and issuing privacy state laws. So the answer to that question truly is they got to catch up, right? And because privacy is here, right? No matter what, it's going to be here. Like we mentioned already, AI, this stuff is here and it's coming more and more. And so companies are trying to catch up. Firms, nonprofits, companies, sport teams, everybody, they're trying to catch up in that way. So to mitigate it, you got to update and talk to, privacy lawyers and especially international, right? GDPR can play a factor. You done with, children under the age or under the certain age, COPPA, the Children's Online Privacy Protection Act. And so hopefully you have a team to help you handle these, and because it's changing every day. It really is.
It is. There's no way to stay on top of it because writing a policy takes time. Yeah. Given that we play in many states and around the world, and we bring in athletes from around the world, and all these companies that are tracking data, they're not necessarily based here. So where is the data transferring to and from is also something. So my personal perspective on this is to take the most stringent laws that are out there. So following GDPR, following COPPA, following California, New York, DC, or federal, trying to keep up with the most stringent practices that are out there, and they're still behind the times. Because anything done by a government entity is going to take forever to get published and get done. It's now not at the forefront either, and we can only do what we can do. For anybody, because there's a lot of students, obviously, in the audience, getting certified. I don't have my CIPP certification, but I started it at one point, so I know enough to be dangerous and to know when I don't know something. But I will likely go back and do the certifications at some point just to have that under my belt and know more, because it is the forefront area that is touching everything. It doesn't matter what area you're talking about. We're talking about sports and sports teams and entertainers and you never know who or where you're going to work in the future, but it's all likely going to have some type of privacy impact because you send an email. There's a privacy impact right there.
Yeah, and a lot of the clients that I work with, the hardest part of a privacy compliance program and keeping on top of it is what both of you just mentioned, that patchwork system that we have in place right now, and not having the ability to have a universal across the board domestic privacy law. I think is really something that creates a lot of hurdles and hoops to jump through. To your point, playing in different states, or if you're operating in different states and one state says this, the next state says that, the little deviations make it really difficult. But to your point, the most stringent standard is kind of what you can follow and try your best to, show a good faith effort, right? That you're trying to comply with these privacy laws.
And to work contractually. So adding that DPA to every agreement, adding in there and putting the liability and risk on somebody else to make sure that they're doing the best they can too. You use our app. Guess what? They have some type of a data privacy addendum attached. Sure. We are obviously, Microsoft is a big one, right? Using Outlook, like getting that into everywhere so that everybody's aware that they need to do what they need to do. I don't care if you're just giving us the software that our players are wearing or the tracking software they're wearing. You need to be responsible for this data privacy as well. And if all of us are, it will help to keep everybody there. And reporting is big. Telling us when you've been breached or you've been attacked or somebody might have gotten in. It's not required everywhere to do that or what the timelines are. And I need to know immediately because I need to take secondary steps.
Yeah, absolutely. And one of the hardest parts of that is because there's this patchwork, framework, and folks are in all types of different jurisdictions. Not every data protection addendum or information security agreement is built the same.
Right.
And a lot of my time on a daily basis is made up of reviewing a vendor's information security agreement or data protection addendum and trying to put it up to the standard that is the most stringent standard, or is the standard that whatever my client has set for their internal compliance program, and trying to see if it matches up. And there is so much gray in what is compliant and what is not. And the other piece of it is, and I love when vendors say this, they'll say, well, this is what the law says. And we always say, well, we can go above and beyond the law, right? Like we can want more stringent standards than just what the bare minimum the law requires. And so I think as that area continues to develop, as the data we collect continues to be more and more personal, not only from the athletes, but from the fans, those relationships between companies is going to become those contracts that used to be just sort of these really simple SaaS agreements or license agreements are going to become, I think, a lot more at stake when negotiating them out, especially on the data side.
Yeah, and the day is about a risk tolerance level, right? Yeah. So every company is different. Every time at the high or low, moderate tolerance level, and somebody say, okay, but is it actually breaking the law per se? And as I've learned the last 5 to 2 years, some companies are willing to pay the fine, right? It's a fine, it ranges from X number of dollars to thousands to, potentially millions. But some companies, depending on the promotion, depending on the situation, hey, we'll pay that fine. It's not like the Michael Jordan thing back in the day. We was pretty fine and create something from it. But we never advise against that. Currently, we always say, hey, as counsel, we advise XYZ, we're paying this. But end of the day, it's up to the company to see how tiring you are for those risks.
Yeah, absolutely.
And keeping in mind that you don't necessarily know everything. I'm in-house. I happen to focus on privacy in some ways, but I don't keep up on the law the same way these two do because they're in firms and this is what they advise people like me on. So if I don't know, figure out who you call to find out because you're not going to know everything.
Yeah, and to your point, like the business risk side of it, right, and being able to advise on that business risk. And I think that, when you look at these contracts, the number one area that you fight on a lot is limitation of liability, right? And because these vendors want to limit because they know that a data breach could happen, right? Their security program might not be as great or up to date as it's supposed to be, things like that. And I always start as an uncapped liability for data security obligations if I can get it. But that's the fight, right? That dollar amount and how much liability there is. And then once you get to a final kind of point, looking to that business and saying, hey, this is the risk you might have to take on, right? It might be a fine. It might be, and that fine might be quantifiable by the amount of data subjects, right? That are impacted. And that's something that someone like Jessica has to decide, which she's comfortable.
Thank you, Jessica. We appreciate you. And I guess go ahead, Justin.
Let's say to bring it back to a human level, the fan level, right? You come to the stadium, we don't use this software, but most stadiums doing this it is possible for people to see this. And you decide you're going to have whatever it is you're going to be drinking and imbibing on, and then you get into a accident or something happens later. If somebody can hack it and get that data, they know you had 6 beers or whatever it is that you ordered, and now you don't have the same fight that you. So the liability is a very strange world, because what is that liability? Am I protecting the athlete only? Am I protecting the organization? Am I protecting our fans? It's all of the above. So having unlimited liability, because I don't know what the liability is for. Did somebody leave the stadium and get in an accident and kill 12 people? That's a different level that I'm thinking of. Oh, we're just talking about they might get a player's injury list. It's very, very broad as to what we're talking about, because it depends on the data that's being collected, and that data is unlimited at this point.
Yes, it is. And going back to the vendor things, yeah, indemnification, limitation liability, IP, licenses, ownership, applicable for the law. I mean, I read a contract the other day that applicable for law with British Columbia. I'm like, I'm not a British Columbia lawyer. We need to. You guys know this vendor is operating in British Columbia? Like, what does that mean? When we have the GDPR, may apply, yeah, because of that. So these are the hot ticket items I look for, right? Clearly, there's some pushback. You got to compromise here or there, but definitely indemnification, limitation liability. That's always like the big one. Say, what are you actually liable for? And more importantly, what do you own, what you don't own, especially when it comes to third parties. I know we have a segment about AI and getting involved there, but it can go on and on and on. At the end of the day, Jessica and others have to make those decisions that we advise them.
Well, I mean, that's such a great segue, because the next thing we were going to talk about really is how has AI changed the risk profile for certain vendors and contractual relationships. And I think as I alluded to, it now makes it, this is a little bit more of a bare knuckle fight when it comes to some of these things like limitation liability and indemnification, because these vendors are, one, they need to disclose that they're going to use artificial intelligence in their process now. And two, we know that artificial intelligence is such an early technology from a consumer standpoint that there's liability out there that we don't really understand yet, right? And so I don't know how you all have balanced that.
Yeah, I think for me, I break it down to like 4 sections, right? I think the first one, when it comes to AI, what data is being sourced from. This is before it gets into the data-driven system, the box, wherever. This is like, where's your data being driven from, right? Is it geographical, the demographics? Where's the data come from? Then the second part is, what data is actually being inserted into the box, into the program, into the software, right? The third thing is, what's the output of that data? And the fourth thing is, what is that data shown over time, right? You can't do it one time saying that's the data, right? You got to do hundreds, millions, thousands of tests to showcase, okay, these are the patterns that the AI is learning, learning is a big word, right? But this is what predictive analytics to show it to happen. And they all come from that. So those are questions I'd be asking and saying, okay, what is generative AI content, especially when it comes to content, right? A lot of these third parties, like, we don't own that content, whether you're a social media provider, whether you're a platform. We just have a site where people can upload content on, but we can't control that. Granted, they have limitations on, is it done with pornography, is it done with violence, obscure, lewd, anything that's obscene to the moderate consumer. And so I think for us, we try to break it down. We try to break down AI into those 4 sections to really divert the data, see where the data is really driven from, and then we can set the legal risk, right? Because we're taking data from one area of the country and say, oh, this is what we found. That's not really predictive, right? You only taking it from a small city in Ohio. As a result, you're showing this leads to that, especially when it comes to consumer health or something scientific related, health claims, satiation, advertising, all those news. So we're the number one cleaner of this. Now we're getting into the deep realm of making sure what scientific backing, competent, reliable scientific evidence, and all those really get into nuance. I'm not, we're not scientists, right? We can just showcase this is what the law says, and we need to prove this in adequate tests, studies, research to showcase. Absolutely.
Yeah, I don't like AI. Start there. No, AI is such a broad thing that I think that's the fear of AI and the dislike comes from there. If we're talking about AI, is it the next gen? Is it current? Is it predictive? What type of AI is it? Is it just spell check on your iPhone is fixing something? Or is it taking my player's data and then feeding that into a full system so somebody else can use that? So when we're looking at these new agreements, and I've got one right now that we're working through, There are 9 million questions to be asked, and we're not even going to get close to most of the questions that should be asked. What is being fed into this system? Is it only my data? Is it only my player's data? If it's only my player's data, then it can only use my player's data to predict something. But what's the actual learning module that's being used? How do you train your system? And then who owns this data, and can you export it to make a bigger system? So there's so many components that go into this that you try to keep everything contained so that we own it all. And at the end of the day, if we terminate our contract, you delete our data. You don't get to use it for something else. Obviously, I think most of us have seen the authors that are fighting back right now because they're feeding in books into these systems. Well, those are still copyrighted. They're protected by laws. You're feeding these books in and being able to create additional things. Are those books biased? So the bias is a big one. I think there's a big lawsuit pending right now with the predictive AI systems created by a hiring company that obviously is using flawed data. If you're looking at data that goes back to the 1900s and you're only talking about lawyers, how many lawyers were of color in the 1900s? How many lawyers were women in the 1900s? So there's a lot of missing information and bias that feeds into a lot of these systems. Our athletes are worldwide, right? So in soccer, it is a worldwide sport. What is the data being fed in there, and which system are you looking at to get that data back out? What's the AI generating? Are we looking for a Premier League team in the MLS? Is that what you're trying to create? Or are you trying to, so figuring out all of that information is one component of it. Fortunately, not the one I'm most concerned about. It's more what's going in, what's coming out, and how do I protect all of that, so that we aren't in trouble for using a biased system and divulging even if it's anonymized, data on our players to somebody else, because it's still one team. How anonymized can you get with 30, 40, 50 people, even if it's over 5 years? It's not going to be as anonymized or protected as we'd expect.
Yeah, I mean, to hammer the point home, that I think you can always tell what's important by the investment of a legal budget by in-house counsel. And I spent 4 months working with one of our clients, putting together an AI addendum, because they have 1,000 commercial contracts that come through every single year, and more their business teams are bringing, because they go to these conferences and they go to these expos, they're bringing back these artificial intelligence powered or solutions that are going to put them in a place where their job's easier. But the business folks don't really understand anything except for what the salesperson from that company told them, right? And so to your point, to figure out all of those things from a legal standpoint, being able to have a process that has, through a contractual relationship that goes down that line of saying all those things and then make sure it protects is so important. But it again, like privacy, constantly changing. And I do think it's going to be quite difficult over the next several years to make sure that we're managing all of those risks.
And I will point out for all the law students and young lawyers in the audience, there's a difference here. These are law firms. I am in-house. I don't have a budget. There is no outside counsel budget that exists. I can make arguments to a stakeholder as to what we should or shouldn't do and how we should engage outside counsel, or I can go figure it out and learn it and spend those hours doing so, because I'm not going to put the organization at risk. And so it really depends on where you're working to determine whether or not you're going to get that funding, that budget, what your bandwidth and capacity is to understand what these are. As you're hearing me speak, I know some of it. I don't know all of it. I will phone a friend if I need to call somebody. I'm going to call Mr. Bingham, like, what do I do here? Who do I call? What do I, call these guys to figure something out if I have to? But usually it's a very narrow thing. Like, I have gotten to this point. I have the league as resources as well, so I can go to them and use their outside counsel if necessary, since the players technically are their employees. So there's a difference there. But there is a difference. If you go in-house, if you work in sports or entertainment, you may not have the same access as these guys do. And they're keeping up to date with everything, and I've got 9 million other things I have to keep up to date with. This is just another thing that's there. But it is critically important, and it's going to be your job to figure out what the most important thing is and where you need to focus your time. Generally, we've all come back to this is privacy related. Everything we've talked about is how do we protect the data? How do we protect the privacy of the individuals?
Yeah, going back, talking to the law students and junior attorneys, as you see, we're all lawyers, right? But we're thinking at the business mind, because that's why I realized the last 6 years of my practice, like, thinking more like what would help the business, right? Like I say, talk about the legal budget, talk about the risk they're willing to tolerate, talk about what they like or don't like, talk about the future too, because sometimes you're not just a lawyer, you are a partner with them. It's a partnership. Your job to help elevate, help alleviate, and help make sure the business grows in those ways. And so that's something, for people to think about, and go into the entertainment world, right? Not just an entertainment attorney, not just a private attorney. Your job is to elevate the business. You're trying to make sure they understand what's going on behind the scenes, from problems. And it's hard, right? Not easy, all right? Because you just come out straight out of law school, you think you're just going to do the law. Like, okay, no, you actually have to make sure that this law makes sense. So I've been learning, being goal-oriented, not task-oriented. One of my mentors told me that at the firm, always like, don't just take a task and say, okay, it's done, right? And that's something I'm still struggling with, right, as a fifth year, making sure, okay, what's beyond this task? What's beyond the grass? What's going more and more? And that's how you get more elevated in whether it's private practice, whether it's in-house, because now you're thinking more than just a lawyer. You're thinking from a business perspective. But I'm saying all to say that I'm still going through that thing. Yeah, I think you as a senior associate are as well, because we were trained a certain way. When you get in the real world, you got to kind of not unlearn where you train, but elevate that more to be that true business partnership.
Yeah, I mean, I couldn't agree more, right? The understanding a client's business or understanding the business that you're in is so important, especially in negotiating and like you said, being goal driven, not task driven. Because there's certain things that, yeah, in an ideal world, I would love this provision to look this way.
Yeah.
But I understand the business, and I also understand the purpose of why we want to partner or leverage this technology. And because I understand that, and I did the research and I did a little bit of the reading to understand how that technology works. I know I could probably give on this, I can give on that, right? I can be a little bit more of a business partner, do my own risk assessment, do my own risk profile, work with the business team to get to a close. Because at the end of the day, like, that's the goal, right? I think that's what they don't tell you in law school. Like, over lawyering kills deals.
Yeah.
And so, the goal is to close. Like, they brought this in because they want you to close it. They want to sign on the dotted line. And so how do you help them get there, but manage that risk and make sure that they're doing it with their eyes wide open?
Yeah, sometimes you go, as a lawyer, sometimes you go in there and you personally go through all the red flags, right? All the markers. And then before you get the deliverable to the partner, to the client, that's when you go and think that business. So you kind of do all at the same time, right? Usually my strategy now is I'm going through all the legal concerns and then go back to, okay, take this out, moderate risk, low risk, high risk. We should discuss. Let's have a conversation about these things. But it does take time. So, and that's something, like I said, I didn't know going into big law, but now the last 2 or 3 years, I'm becoming better at it, right? Every time I'm getting an assignment, I'm not just saying, what is the email saying, keep it going. I mean, I'm understanding, okay, I read down the whole email thread now. I look them up to say who this person is, and really making sure I'm providing the ultimate value to them as, private practice, and we get, assignment from there.
Yeah.
And then once you get to my point or my position, it is I have heard everything they have to say. We're going to take the fine anyway, which is going to annoy the hell out of them because I just told them you did all this work for no reason, so I'm taking the fine. But it is always going to be a risk analysis. Do we pick up this contract, this player, this whatever it is, and move forward with it knowing that we've just picked up risk? What is the risk? How much is that risk? Is this risk $1 million? Is it $5? Is the fine $1 million every year? Are we going to lose players? Are we going to not be able to bring people in for some reason? What is that risk? And then if it gets to a certain level, I will actually take that up above and be like, hey, here's the risk. What do you want to do? I recommend this. And they can overrule me. I am still just the lawyer at the end of the day. They are the client. And that is a hard thing for a lot of people to realize. I am still a lawyer representing an organization. That organization is the single client. And I learned that organization very well and that client very well to know where they're okay with risk. And I have a lot of autonomy to accept and push back on things. But at the end of the day, if it's this deal is either happening or not happening, I will take that to the head person that I need to take it to and be like, here are the 2 points. And they'll say, we're out or we're in. And I'll then go in that manner. And typically people come around after I told them the business side says we're out too.
Yeah. And so I think we're running out of time here. So I really appreciate the conversation. I want to give an opportunity for either of you to kind of wrap this up, saying anything that's still on your mind, and then we go to questions.
No, I mean, like I said, entertainment media, I loved it. I guess a little bit about me. I used to be a DJ and chess instructor before this whole law school thing.
Was the DJ in there?
Well, now with DJ Esbar. The other things, don't worry about it. Over in there. So that's how I kind of got involved in the world from a consumer perspective, right? And understanding it from a lay person and going to law school. I knew day one I wouldn't be in this world, right? But like I said, I think a lot of people, because this world, I get a lot of LinkedIn requests, a lot of messages saying, I want to be this, right? Oh, but this takes some work. And not just, it may be cool to say shiny, but it's a lot. And there's a lot of things I don't know, a lot of things I'm learning, and it's changing so fast, right? It creates a lifestyle to make sure like you always want to be on top of it, right? It's especially the privacy world that's changed on a daily basis. And so I guess my biggest advice is like my mentor told me you have to be all in entertainment. If you want to be entertainment media, be all in, right? Make sure you watch all the world shows. Make sure you watch the Super Bowl, watch the big events. Make sure you follow up and look the people doing the work. Make sure you attend panels, COEs. Be engulfed into the world. And you only learn by listening to the same thing over and over and over again. That's the way I learn, right? You can't just read something one time, say I got it. You gotta be engaged with the material. You gotta be really making it part of your daily routine. So for those law students and junior attorneys, I'd always here reach out, for advice because I'm learning the game too. Well, appreciate Derrick for moderating us. Hope you did a good job. And I'm ready for questions with Jessica.
Yeah, I mean, I would agree with most of what he said. It is something you will have to immerse yourself in if you want to be in, and I wouldn't just say sports entertainment, but IP, tech. These worlds are fast evolving areas and they are multifaceted. Some people know that I got off a plane at 5 a.m. from South Africa yesterday and went in the office at the stadium by 8 a.m., and then at a law firm event that ended at 9. It is something that is not for the faint of heart if you can't keep up. It is a lot of learning and education that you're not going to be rewarded for. There's not going to be somebody saying, oh, I'm so glad you knew about this privacy thing that was coming down the pipeline and you protected us, because they're not going to realize they were protected because they didn't realize it was an issue that was potentially coming. You just do your job and eventually that's recognized and you're moved up in the world and will get to where you want to be. But it is a lot of continuing education and learning and, being at the forefront of whatever you can be at the forefront, but also understanding you're not going to know everything. You're not going to be able to be at the forefront, but you build a network of people that are in those positions so you can make that call to whomever you need to call should you have a question on something that's not your expertise. And then you delve into it. Be involved. If you want to be in sports, know all the sports. I didn't know soccer before I took this position, so I was entertainment, I was IP, I was not sports. And guess what? I've learned soccer. I can learn the sport. I knew how to do the law side of it. And you learn it as you go, and you make sure that you stay at the forefront and you go to the events and you go to the CLEs and you go to the panels, because it's real easy to get into I got the job. Let me just back off a little bit. And that's not going to keep you there or progress your future and your career.
Yeah, absolutely. I mean, we always say around my office, everybody wants to be famous, but nobody wants to do the work, right? And if it is, it's a lot of work and not for the faint of heart. But I do think that the intersection of technology and sports, technology and entertainment, intellectual property in sports and entertainment does create this opportunity where, you might not be a traditional entertainment lawyer or traditional sports lawyer, but you have so much to offer by maybe working in technology transactions or data privacy or intellectual property in getting those reps in and being at the forefront of that and finding your niche within the law that will allow you to provide value in the entertainment context, especially as artificial intelligence and data privacy that are so rapidly evolving become more and more important in those industries. So I appreciate both of you. I'm going to open it up to questions if we have any.
While we wait for questions, I'm going to reiterate the CIPP training, the certification in privacy training. I highly recommend it. If you're on the fence, if job's on the fence about you and you're like, oh, they've got this, you're going to be that leg up. It doesn't matter what area you work in legally, no matter what area you're in, privacy is going to come into play. Whether it's something as simple as HIPAA that most of us have heard of our entire lives, or the AI world that we're talking about, or children, having that privacy certification, even as a personal injury attorney, because I had health records I was looking at, is something that is going to come into your world of life in general, but also legal practice. So if you have the time, go get the certification or at least do the studies and figure out what's in there so that you have some idea of what's going on.
So with regards of digital social media platforms, how are traditional entertainment contracts are the ability to best in bus or constitution?
Sorry for the question.
Yeah, I'm sorry.
You're right. It was hard. Sorry.
Yeah.
With the rise of digital media platforms, how are traditional licensing contracts evolving to address the needs of constitution?
I could maybe attack this at first. And so one of the considerations really is trying to know that we don't fully understand exactly where certain trends are going to go. And so the way that we try to approach those contracts, specifically with talent, is trying to keep it as broad as possible, right? And make sure that not only are we accounting for across the digital media platforms that exist in that moment, but also keeping our minds to where it possibly could go and focusing a little bit more on the content that they're creating and how we attack that language within a contract, as well as what we control in terms of their content creation. So that has been a challenge because there are, I don't know if everybody here remembers Clubhouse, for instance, right? There's these media platforms that can pop up overnight and become the it, right? But then they could be gone just like that, just like Clubhouse was. And so, that is important because there was talent at that time that Clubhouse was a thing that had some vagueness around their contracts, right? Like, yeah, you have maybe TikTok, you have Twitter, you have, or I guess X, you have Instagram, in my contract, but you don't dictate what I do on Clubhouse. So I'm going to enter into maybe a different agreement with a different company for my Clubhouse content, right? And obviously the folks that thought they owned all of their social media content and how we define social media and what social media is has become very important to focus on. So just trying to attack it from a broad sense. And then the issue with that is obviously working with their counsel because they are not going to want it to be broad, right? So when I'm on talent side and not company side, I'm sitting there and I'm saying, well, no, you need to list out very specifically what our requirements are, what the obligations are, what channels of and digital platforms that you're referring to, so that we know what our obligations are. In the back of my head, though, I'm also thinking, because I want to make sure that you list everything so that later on we might have some flexibility and avenues that we can go down that aren't within what you set forth in the contract.
Yeah, and for those that may not have heard the question in the audience, it was regarding how entertainment contracts are basically shifting to approach new media and new content platforms. I can't speak to current in the same way. However, 20-ish years ago, I interned at one of the big 5 entertainment studios during law school, and the job that I had there and my entire internship was based on was figuring out how to get the rights to use music in new media distribution manners, right? So at the time, I think MySpace had just been launched. YouTube was in its infancy. And if you did a movie back in the day, any movie before 2000, really, it didn't have the right to digital distribution. It didn't have the right to home video necessarily, because those were all the new media that in the new distribution platforms back in those days. So what I saw in my years after that in the entertainment world is, before people started realizing we were going to have now the Clubhouse and the other things, is that we just took the rights to any and everything. If we had the power, we were taking the right to any and every platform, now known or hereafter devised, in perpetuity throughout the known universe. I use universe because we are using satellites and there are arguments that can be made there. So, and I've been doing that since 2007. If I was in the position that I could, and most people didn't know what was going on or why I was putting it in there, so I got away with it. Now people are sophisticated enough to do this. I can assure you that if I have to draft a contract for a new player or something that I have control over, I am going to make sure that I have the rights to any and everything possible. Shameless plug for Audi Field. We do host the Howard Hampton game. It will be coming back to Audi Field this year. And that is one that I negotiate with Howard on that contract. Well, what rights do I need to have in order to actually air whatever that show is? And then give those rights if we want to sell it to whatever the entity is. So I'm still in the world to make sure that we protect those rights and get them, but it is less in my world because of the sports side of thing. And it's just making sure players have their ability to go do their things, but they can't go create a show on their own and distribute it that uses our IP and other stuff.
The amount of people that have given up their rights in the whole universe is nuts, though. Yeah, it's actually really crazy.
Taking the universe.
the universe.
For the future of your life.
I hope I answered your question.
Yes, please.
Can hear you pushing back. Is data tracking of players, does it be a detriment to their contracts and incentives?
Sure, you want to touch that first, Jesse?
So the question was, can we see unions, the player unions, pushing back with regards to the data tracking? Absolutely. I mean, the CBAs, the collective bargaining agreements are done every so many years, and I'm sure that will be a hot topic in the next one. It is actually in the most recent ones as well. It is in the two of the two of the four that I deal with right now. Well, one doesn't exist yet. One is being negotiated. I'm sure it will be in there. So it is something that is heavily negotiated, but players also understand that without that data, it's really hard for us to help you get better and more fit and do the things because we're not in the same position we were. There's always arguments of who's the greatest player of all time. Well, people are very different today with the advent of medical science and pushing people forward in that way and getting fitter than they've ever been.
Yeah, like most issues in the union, there's going to be some type of compromise, right? The stadium, the league, the venue needs that data to promote the good of the sport, right? Whether it's data analytics, whether it's an endorsement, whether it's a sponsorship, right? So they're going to have to give up some data tracking right now. Once again, does it have to be during the off season, during training, only during game time, during the season, right? Those are going to vary, but it won't be as in quick. No, data track can't give up because this data tracking actually helps support sport and broadcast dollars, media deals, all the things. All about money, right? Sports. We saw the new NBA deal. We saw the new NFL and CBA agreement. All these stuff is all because what more money is coming to the sport. So we need that to showcase our evidence. The people are watching it at these certain times, viewership, the whole TNT thing with Amazon Prime. It's all because of the data being collected from the athletes and from the viewership.
And the last thing I'll say is that it's also important to remember, like in certain industry verticals, like health tech, for instance, there's innovation coming out of that is it's saving players' lives, right? It's preventative. It's catching things that we traditionally would not have seen. Exactly. Wemby, they've had players in the combine, right? Through the testing and through the data tracking in the combine, find out that for 24 years they were living with a disease that ultimately could have taken their life if they would have continued living the way they were living and not been gotten preventative surgeries or other things like that. So I think there is like a balance here, and this also is extending careers in putting people in a better position than they otherwise were, not just from optimizing their performance, but from saving their lives. So there's going to be a balance for sure. And Charlie's standing on my right, so I'm going to take that as it might be time to wrap it up. I really, really appreciate you both for joining me. I appreciate all of you for coming, and those in the virtual world, thank you for listening.
It was a whole wrap there. It's you guys, I'm big on energy, and you guys, you can continue if you have questions. I just got ran down here like, all right, Charlie, you got more responsibility, but I'm like, they handling it. They got it. So if anyone has any other questions, I'm not gonna stop you all from asking your questions. I know sports and entertainment is a cool area. Anyone? I'm just curious. You talked about the players' data and how that kind of generates the revenue because you can turn around and sell it. These touchdown celebrations, that like Madden has, if anybody's played a game, that like they're real specific. Have you all seen special monetization or trademark of, like, we all know Dion used to have his, like, that signature. The game will charge you extra just to do Dion's signature thing, but I'm wondering, is anybody negotiating special rates for this is tied to my brand? This is not just a generic ball spike. This is who I am. I can't think of anybody who has like a very signature.
I mean, it's all them, Justin Jefferson with the gritty.
It's not even his.
That's what I'm saying. Like, even promoting that, right? Commercials is on everywhere you see it, the kids are doing it. They say, Jetta. You have Cheetah, Tyreek Hill with these are things that have been around so long. But the shoulder, but even LeBron James with the stop, right? And that's been around since the 90s, right? But now people say, so I think athletes understand that this is part of my brand, right? So actually it's a kudos to the athletes as a talent to show, like, this is my brand. So I want this negotiated in my next contract, in my next endorsement, because especially if a Hulu, if an Amazon, if some sports drink put you in that commercial, like, people know me for this now. So I do think, I don't know, I'm sure that negotiating special rights for that to get the extra dollar or two, I'm sure.
But it is important, and I'm not a trademark lawyer, I'm not an IP lawyer, but historically, our courts have said that it's very difficult to own the IP of a dance, right? So there is an avenue that folks had tried to go down to try to own those dances to then make sure that they're able to license it and gain from it. But ultimately, that has been futile.
And I would posit that it will likely be an NIL type protection.
Yeah.
This is his likeness, this is his thing, and you're trying to capitalize on that by putting this individual into your show that looks like him. You're using his name, image, and likeness in a dance that he does, and it'll be a combination of things that gets them in trouble and gets the lawsuit that changes that rule on dance.
That was the whole Fortnite situation. All those dance moves, all those character development. They had told people permission license, but that's what was a whole big ordeal. So I think it'd be a combination of some license right to do, especially if that's my biggest thing is you put in a commercial and you're doing that commercial and people see it, that's part of your brand. So that could be one of the leveraging tools that a talent can use to say, no, this is becoming.
And from an athlete perspective, if I'm the next superstar and I'm doing this thing every single time, the next Trinity Rodman, right? And you're doing this thing every single time, well, the next club that I go to play for, I'm going to negotiate a higher salary because I do this. And every time I do this, ESPN plays it. So you're getting more footage. So the athletes aren't unintelligent. They know this, and they've got agents and lawyers out there that know these things and will argue these points for them. So I expect to see it become a bigger thing as time goes on.
Yeah. Okay. Sounds like the area lawsuit is says right for research and a paper.